Good morning, everyone. I'm Margie Graff. I'm President and CEO of the Greater Rockville Chamber of Commerce. Welcome to our webinar today. A few quick items to note. If you have any questions during the presentation, please put them in the chat. And when the presentation is over, we'll go through the chat and get your questions answered. If you're not speaking, please mute yourself until the end of the presentation. And any comments in this presentation are not the viewpoints of the chamber. Just getting all that clear. So now I want to introduce you to John Flood. John is a lawyer who has practiced in the area of employment law, primarily for employers and business owners since 2002. John opened Flood Law, LLC in Rockville in 2020, where the firm continues to help employers and business owners with employment law and other business-related issues and court cases. John also serves as a member of the board of the Greater Rockville Chamber of Commerce. And John, I'll turn it over to you.
Great. Good morning, Margie. Thank you so much. And we appreciate the chance to partner with the Chamber on this webinar. We're really excited to be able to have this conversation on what truly are, I think, breaking topics that are very important to every employer. Margie, could we go to the next slide? So I want to introduce our two panelists who have joined me for today's discussion. And we couldn't do any better. We've got two outstanding experienced employment lawyers to help discuss these issues with us. Joyce Smithey with the Smithey Law Group based out of Annapolis is joining us, and Joyce is highly experienced attorney, and she and her firm, I know over the years, I believe she's represented employers and individual employees, plaintiffs in litigation, and now I believe her firm is focused on representing individual employees. And our other panelist is Aisha Massengill with her firm is Sedgwick Andrews, located in Columbia. Aisha has a wealth of experience, in particular helping employers and business owners deal with employment law issues. And they're both Maryland lawyers and will offer, I think, some really valuable insights for us today on these issues. And I'm pleased to moderate the discussion and hopefully not get in the way as we go along. We can go to the next slide. And so as you can tell from the title page, the title of our webinar, and then there's reference here on the title of this slide, we're really going to drill down on three executive orders that have been issued by President Trump on and after Inauguration Day on January 20th. I was trying to think how to describe these changes to give analogies for you all, at least that come to my mind. And, earthquake, whirlwind, tsunami, to me were sort of images that came to mind. I didn't write it up here, but what do they all have in common? They're all potentially natural disasters, right? So for some on the call and some employers and business owners, these changes, and even employees, of course, these changes may be thought of that way. Wow, these are really, in some ways, rolling back the clock on developments that have occurred over, especially the past few years, under the Obama administration, then later most recently under the Biden administration. Others may feel differently. We're not here to judge or necessarily put forth a specific viewpoint. All viewpoints are welcome here. All we ask is that if you have questions, and if you in asking those questions, we'll just keep our views professional, which we know everyone will do, even though these frankly can be quite highly emotional issues, no doubt, for anyone that's affected. Next slide, please. And so why we're here is three reasons. One, we want to alert you to these changes. You may have heard of some, but not all, or may not have heard of any of these within the past 2 weeks. We want to highlight key questions and issues that we think may arise for you in your company and business, and then also through our discussion, help you begin to consider steps to take to address these issues. Next slide. All right. The three key executives orders that we're really focused on today really focus on issues, number one, diversity, equity, and inclusion programs and preferencing in relation to government contractors, but also companies that may not deal with the government, but in the truly private sector, if you will. Obviously, in the discussion, I think will make clear, government employees are definitely being affected by this. Of course, they're being affected by many other things at this point. The second will deal with rescission of a long-standing executive order relating to affirmative action and non-discrimination by government contractors with the federal government. And the third executive order deals with the rights of women, but really focused on and impacting transgender persons' rights, both within the U.S. government workforce, but also for employees in the private sector. The next topic and final topic we'll talk about, we think is equally important, and Joyce will review for us there the status of a ban issued, I believe it was last year, by the Federal Trade Commission under the Biden administration against the use of non-competition agreements with employees. Joyce will talk about the status of that in relation to certain court challenges that have occurred and are ongoing, and where she thinks the Trump administration may go on that issue. Next slide. So kind of how has this changed? How have these changes come about? Think back to the whirlwind, the earthquake, the tsunami, right? It's come quickly. On Inauguration Day, that I have as President Trump issued 26 executive orders, that significantly higher number than President Biden or President Trump in his prior term issued on day one. On and after Inauguration Day, President Trump has signed, I believe he's up to a total now of 45 executive orders. The three we'll talk about again are those we think that most directly will impact employers and business owners. A key thing I know we'll emphasize throughout the discussion is that we'll look at the executive orders, but also be aware that changes will be ongoing. And our final comment on this slide is really alluding to that, because the rubber meets the road, if you will, when an executive order is issued, for example, in this case, by enforcement approaches and actions taken by agencies with authority over a certain set of issues. Relevant for today's discussion would include the EEOC, Equal Employment Opportunity Commission, the Department of Labor, once the new Secretary of Labor is installed and confirmed and installed. And then in relation to union issues, employers who have to deal with unions in the workplace, members of the National Labor Relations Board, as well as the General Counsel and other leaders in that agency. All right. The key executive orders we're focusing on, the first one, ending radical, and these are the titles, right? Ending radical and wasteful government DEI programs and preferencing. And that, it didn't have the number on the slide, but in case you want to write it down, that's Executive Order 14151. The next was issued on January 21st, ending illegal discrimination and restoring merit-based opportunity. And that's the one I mentioned earlier that rescinds the Executive Order 11246 that deals with affirmative action and non-discrimination for government contractors. And then the final one we'll talk about is the executive order entitled Defending Women from Gender Ideology, Extremism, and Restoring Biological Truth to the Federal Government. All right, I'm going to hand it over to Aisha. She'll take it away regarding the first executive order we'll be discussing today.
All right. First of all, thank you so much to John and to the Chamber for inviting me along this exciting topic. I am someone who typically thrives on the energy of the people that I'm speaking with, and it can be challenging at 9:40 in the morning, not being able to look you all eyeball to eyeball. So if you feel so inclined, especially those of you with your cameras off, you just throw up a thumbs up sign in the chat or give me an emoji to know that you're all paying attention and it's just not me speaking to names in the boxes. I would surely appreciate that, just knowing that you're out there and actually alive. Um, so it's been an exciting time for employment lawyers, and I would say the country generally, but for us in particular. And I thought, just a quick, thank you, Ben, just a quick review of what all the fuss is about, what diversity, equity, and inclusion is really about. So the way that I think of, thank you all for the thumbs up, appreciate you. I know that you're listening now, you're locked in. Um, Diversity is the mix of folks that you have in your workplaces. Equity is different from equality. Equality means everybody gets to come to the party. But what equality doesn't often recognize is that there are obstacles sometimes, even if you have an invitation, the road there might be more challenging. So if you think about in the military, or some of you may be golfers, golfing from the women's tee is a way to make more equity, right? So that everyone can still use the golf course, but you might have a women's tee. You got to hit a little bit more close up. I don't golf, but I'm just throwing that out there as an example. My favorite visual for equity is when you have people are, because I think I saw Jared with a Cal Ripken jersey on, so he will at least appreciate this, that people are in the outfield and they're trying to see over a fence into the baseball park. And everyone has equal access, but if some people are taller or some people are already standing on one box, but other people are stacked on other boxes, they're not all starting at the same place. So equity means let's really acknowledge that everyone's not starting at the same place. And I think that part is really important to set the stage for these DEI discussions because it sets everything up as if diversity means we're requiring employers to take less than. It sets you up for failure because baked into all of the discussion is diversity automatically means you're taking someone who's less qualified, right? And then the inclusion part is like everyone has a place at our table, making sure that everyone's included. And so that's just really important because even if you look at the statute, the original statutes, it is designed and it is acknowledging that there are certain groups in the country that didn't have that same starting point. Okay. And it is an effort to try to help people catch up. But it doesn't mean that employers are required to take less than or less qualified than. But in the executive order, the president issued immediately, we were all kind of waiting because there was actually a rumor that there were 100 executive orders that he was ready to sign on day one. But he did, as John noted, sign a flurry of them. The first one ending this radical, wasteful government and DEI programs. And so he went in immediately across all of the federal agencies and terminated DEI and I think the A is accessibility programs within the federal government. It explicitly rescinds initiatives stemming from executive orders from the Biden administration and affects federal employees practicing, training, policies, etc. Many of you who may have government folks also may notice that job postings came down. People who hold these positions were invited to immediately depart. And so everyone in the federal government is scrambling. They have a 60-day timeline to actually implement the changes. So it is getting rid of your chief diversity, equity, and inclusion roles. If you had an equity action plan, a lot of this accelerated after the killing of George Floyd, where a lot of both government entities and civil entities, adopted plans to try to increase their diversity at their organizations. Any kind of environmental justice programs, which may deal with like your urban environments. People, when you think environmental justice, you automatically go to like farms, but not just farms, like, people who live in cities and maybe they live in food deserts where they don't have access to appropriate supermarkets, et cetera. So anything related to that, any kind of performance requirements with contractors and guarantees, et cetera, as you can see, it's potentially far reaching for folks who may have certified 8A organizations, for minority-owned businesses, women's-owned businesses. All of the spigots for those things are being turned off throughout the federal government and throughout the contracting industry. Next slide, please. Thank you for the thumbs up. I'm just catching up here with Ashley, Ruben, and Brad. Importantly, there are things that the order doesn't change. And it actually is like, shouldn't be earth shattering, right? Because I started the conversation by saying DEI never said you had to take people who were not meritorious for the particular role for which you're hiring, right? So any merit-based requirements, you can still have those. They actually never went away. Fair treatment obligations. I think most employers think that they do their level best to be fair. Any kind of anti-discrimination laws. This is really critically important because for now, we don't have a king. So there are limitations to what executive orders can do. And our, I guess, bedrock statute, the bedrock law for employment attorneys is Title VII. And that's something that Congress passed in the 60s. So that doesn't magically go away. And so we've been having conversations amongst our panelists about the inherent tension for an employer that needs to now worry about folks who still feel like they may be discriminated against, and then the impact of these executive orders. And so it really feels like it leaves employers between a rock and a hard place because now everybody's unhappy, right? Everybody feels like they're not getting a fair share. Everybody's unhappy. So how do we deal with that? The order characterizes the bad DEI programs as illegal and immoral discrimination programs. I think for all of you on this call, and I know for me and the employers that I've either worked for or advised, no one's going about this business being like, we're going to do this on illegal, we're going to do this little thing. No, we're all trying to comply with the law. And I think most of us, when the decision for the Harvard and North Carolina came down from the Supreme Court, most employers went through their programs and evaluated them and said, like, are we still good? And I think most employers felt good about that, or they tweaked as they needed. But we just need to be mindful that this is how the government is characterizing certain DEI programs. Many DEI programs were specifically designed to ensure compliance with the law and prevent discrimination. And you'll see that actually in the next executive order when we talk a little bit about the OFCCP as it existed before the inauguration. Next slide, please. So just some final things on this particular executive order. I talked about when the Students for Fair whatever with Harvard, that decision came down, employers, we all scrambled to say, like, our program's correct. So we want to just do that again, right? Audit the internal and external communications. Some of the things that I've said is, you can still have these programs, but you don't want to court disaster because, either the government's now going to get you, or maybe Joyce comes to get you. I don't know which one. So we've got to be able to look at how we communicate about our programs, both internally and externally. For private sector employers in particular, looking at your recruiting programs, do you have programs that are targeted to historically Black colleges and universities or Hispanic serving institutions? Are you still using diverse recruiting slates, succession plan considerations? Again, what's on your website? What are you doing for training? In Florida, for example, they have like an anti-woke statute that actually disallows you from doing DEI training. So I suspect we'll see more of that coming up in the coming year. For my contractors, thinking about your streams of federal funding, are there ways that you can go to other paths? I will say, in the nonprofit sector, people are really spooked. And I've had friends in nonprofit who, like, they've had grants pulled because those grantors are nervous about becoming a target because they support certain organizations. So everyone's nervous now about what to do. Again, consider the impact of making big pronouncements. If you're Costco, you have, I think, the financial wherewithal to come back out and double down on saying we believe in DEI. I would say, are you a tanker or a speedboat? If you're a tanker, you can take on some hits, but if you're a smaller boat, taking a hit to your business might be more substantial. But I would also give some words of encouragement. Research has shown diverse organizations still perform better financially, operationally, for businesses. So really, don't run yet. And until there's an amendment by Congress, Title VII is still the law of the land. I'll pause there for John to get in and for Joyce to get in.
A couple of questions, Aisha, for you and or Joyce may want to comment too, and Margie, could you go back to that prior slide? So the first on the left column, Aisha, under final considerations, ensuring the focus is on merit-based decisions, and then below that referencing recruiting programs, diverse recruiting slates, et cetera. Even with the executive order, do you think employers can still cast the broad net, even with intentionality, to try to make sure maybe underrepresented people, applicants, are being given that greater, not a more available opportunity to apply for and be considered for certain positions?
I think so. I think that you start with what is the role that I'm recruiting for, right? And if I'm going to an HBCU in this area, it'd be silly not to go to Howard. It'd be silly not to go to University of Baltimore or something to look for folks, but you're still going to source qualified applicants. And I would say so long as you're also visiting PWI, predominantly white institutions. So if you're not going to those schools exclusively, my guidance would be it's fair game.
So in trying to cast the net for broader inclusion of the applicant pool, but not to the exclusion of PWI.
Right. And that's the same pivot that organizations have had to make about their employee resource groups, right? You may have resource groups that are for women or for parents, but they have to remain open to all. So I think if you still have that principle, like we're still going to many, many colleges, but we recognize, I would say, if you fish from the same pond, you're always going to pull the same fish. So you have to go out there to different kinds of institutions so that you get, a varied type of folks. And I think that that's still fair game.
I've had it mentioned to me, and I've thought of it myself. Is the trick here just to change the verbiage? A DEI, director, vice president. We're just going to change that person's title, but still really kind of have the same program, or is it more substantive than that from what you're seeing here?
I would have said phase one after the Harvard decision, it was just change the titles. A lot of people went to inclusion and belonging titles, for example. I would say post inauguration, particularly because in the federal government, the administration has developed these bounty programs and whistleblower programs to say, hey, if they're still doing DEI in your agency, let us know. That's a little bit more of a dicey practice. And I think leaning into belonging is okay, but just simply having a title change is not enough. Again, I always say to my employers, a lot of it is what is your risk tolerance? Okay. Because John will tell you, Joyce will tell you, like, I can't guarantee you will not be sued. And so if you have to decide what you have the stomach for, right? We can say some people more conservative, how much fight do you have in you?
Very good. Well, let's continue. Aisha, I think you're taking on the next executive order.
And yeah, and Joyce, feel free to jump in. So continuing the illegal discrimination and restoring merit-based opportunity. Um, this is what the Federal Register looks like. We can go to the next slide. So this one is interesting and far-reaching because it eliminates an executive order that was signed by LBJ, establishing equal employment opportunity. And the key thing here is a lot of times people conflated affirmative action with DEI. And this executive order leans into the affirmative action piece that if organizations have gaps in their representation, there is naturally, based on your population, et cetera, a distribution in your workforce that you would naturally see. And if you've done a reduction in force and you do an adverse impact analysis, what the labor economists and the numbers people will spit back out to you is, what would I expect to see if things were done fairly? And so this order eventually became embodied in the OFCCP, which many of you who are contractors on this call are familiar with. And so this is saying that contractors now have to certify that they're not operating these DEI programs. And it's like, even my saying these DEI programs makes me feel icky. Makes it sound dirty, these DEI programs that violate the anti-discrimination laws. And a big thing that we all talked about is there may be material changes to your payments based on compliance. And without throwing out, big scary words, in essence, if the new administration finds credible information that you're violating their new executive order, they may stop payments or they may file claims against you to recoup funds from you because they feel like you're in violation. But you do have 90-day transition period to address this. The other thing, many of you are familiar with OFCCP, there's a lot of chatter with employment lawyers that that organization will cease to exist in pretty short order, which will, I mean, in some respects may be a relief because, there's some compliance things that you won't have to report on, like some of the wage transparency things that we've had to deal with. But for the other, taking good faith affirmative actions to make your workforce more inclusive, that's going to change. What we always have to be concerned about on the private sector side is whatever the federal government does, it has a trickle-down effect. So as we saw after the Harvard decision, many employment lawyers tried to tell our clients, hey, that decision applies to folks who receive federal funds, contractors, government. It doesn't apply to the private sector. But in essence, it creates a playbook for the private sector. So there's a guy, Robbie Starbuck, for example, who's running around terrorizing companies. And then every time he gets someone to walk back their DEI statement, he puts out a TikTok or an Instagram. We got another one. We got another one. So unfortunately, the private sector has to watch out for it. Just for any interest of time, these are, the special focus on the organizations that he's looking at. And then we can just go to the next slide. What remains protected? Anything with veterans' preferences, First Amendment speech, academic instruction, state and local government speech, that's still going to be protected. And I would say overall too, anything that's disability related to me is still fairly safe. So veterans and programs involving disabled persons, you're still likely okay on the risk spectrum. A lot of the guidance that we would give, though not legal advice, but guidance is not earth-shattering, but it's just making sure that you're reviewing your current contracts, working with your attorneys to make sure that you are compliant, much like the last section, making sure that your hiring practices are up to snuff, and just having more sensitivity to these issues and really leaning into the qualifications. And sometimes in organizations, we may have leaders who like to hire on gut, and we have to really, I would suggest that this may even be a tool for my HR friends because it really causes you to be more structured in some of your hiring practices to make sure that there is a connection between the qualifications and the individual chosen. Next slide. We can skip this slide. So I can take this one, or Joyce, I'm just mindful of the time and I want to like share, I feel like I've been talking forever. So
I know you're ready to speak on this topic. I want to just add a few things.
Yep.
Coming from the employee perspective, yes, I represent employees that bring actions against companies. I'm also a business owner and I have 20 employees, and I have never felt more empathy and sympathy for business owners than I do right now. I mean, we've talked about the hard place with Aisha, and I just want to say, meet the rock. What do you do with your DEI employees that you're not allegedly supposed to have? Although, I think a great title is something like merit-based hiring director. But here's another problem, right? So the EEOC is still responsible for enforcing Title VII. Executive orders cannot change federal law like Title VII. They cannot change the Constitution. They cannot take away state laws. And so as you're dealing with terminations of these DEI employees, if that's what you're contemplating, you have to look at the potential violations of existing law like Title VII. It's illegal to retaliate against people for addressing workplace discrimination or advancing EEO protections. And that anti-retaliation provision to Title VII, to Maryland's Title 20, which is our state anti-discrimination law. DC has its own as well. These anti-retaliation provisions are all out there. So, as you're figuring out how to comply, don't forget that these employees have some rights as well. And as a prediction for all of this, I think you can expect to see those employees, especially, I agree with Aisha, I think the OFCCP is going to probably go away. In the meantime, it's been severely curtailed in the instructions not to promote affirmative action. I think you can expect employees to move towards state commissions, the Maryland Commission for Civil Rights. You can expect to see them move towards the county commissions. Howard County has an active one. Montgomery County has a very active one. So you should expect to see that. Maryland State, if you've looked at the governor's budget, has added 15 new investigators to the Maryland Commission in the budget in preparation for what we think is going to happen. So this is a pretty popular thought that this is where your employees are going to go with complaints. I know that we have a State of the State address from Governor Moore today at noon. Will he name check Trump in these executive orders? I don't know. We've certainly added our state into some of the lawsuits that are out there. But we've also heard Governor Moore say, I am not the leader of the resistance. So we'll learn from that at noon. But I just wanted to add some employee perspective before we move on to another rock in a hard place. And I'll turn it back to Aisha.
And actually, before Joyce or Aisha, so, and there would be more detail to the scenario, I think, to fully assess it. But is it possible an employer may run into a conflict between federal policy, as announced through the executive orders, maybe enforcement guidance and strategy and efforts by a federal agency like the EEOC versus their understanding of the requirements of Maryland state law against discrimination in the workplace?
So now, John, you're going to try to make me go back to my law school, like 1L constitutional law thing. So help me, Joyce. But there are certain issues that remain, and this will come up, I think, in Joyce's talk about non-competes. There are certain issues where the federal government reserves the right to be the authoritative voice. And there are certain issues that remain for the states. And I anticipate that there's going to continue to be this friction. And Mayor Brandon Scott in Baltimore, for example, filed a lawsuit amongst other people today against the administration on the DEI order. So perhaps he's the head of the resistance. I don't know. But I think that there's going to continue to be this friction between which one do we follow, and what are the areas where the federal government retains the right to speak exclusively. What does the state say? No, this is our area. The only thing I remember from law school is like insurance. insurance. I think the state always gets to speak first about insurance, but there are other things like if there's tension, this stuff is all going to end up bubbling to the Supreme Court. It's just going to be, for the lawyers, geeking out, like it's fascinating.
Yeah, I agree, Aisha. The area of law called preemption, right? What does federal law cover to an extent that means state laws can't do it? And essentially, if the federal law hasn't covered the issue, state laws are free to give more protection, expand on what's happening there. And I think we can continue to see that. John's question is it possible we'll feel that conflict? I think it's probable we'll feel that conflict.
And Joyce, like the Maryland statute relating to non-discrimination employment, my recollection is courts have typically at the state level looked to how courts have construed the federal law Title VII, but it may not have to be in lockstep. It's not to the point of preemption where a Maryland court could not deviate in construing the Maryland state law on the issue and go a different way than a federal court, in the local area perhaps may take on the same issue. Is that accurate?
Very accurate. Certainly, there's a lot of looking to federal body of law to interpret Title 20. Title 20 isn't as old as you might think. We were one of the last states to have a private right of action for discrimination. But you're right that we look to that law. But for example, we have a very active legislature. Our legislature created a different definition of sexual harassment by statute. We have a slightly different definition of disability. Title 20 expressly includes categories of protected classes that aren't in the federal law. So there's certainly precedent, both legislatively and judicially, for Maryland courts to veer away from what the federal body of law is doing.
Very good. Aisha, you're going to take this up?
I'll take this.
Okay, very good.
So this executive order is the bathroom executive order. This is how I think about it, keeping bathrooms safe. Next slide, please. And so the federal government has issued, basically a policy statement that there are only two genders, male and female, that they're not changeable and grounded in incontrovertible reality. And so the government has said that they will double down on just cisgender, male, female in everything. The reason why this is a little bit eye-opening, again, in the legal community is back in 2020, interpretation of the statute had actually left the issue of whether or not sexuality was protected. Traditionally, we knew when you're looking at a sexual harassment or sexual discrimination, male and female had protections. What was unclear was whether sexual orientation was a protected category. Again, to that federal state delineation, a lot of states, including Maryland, had acknowledged sexual orientation as a protected category. The Supreme Court in 2020 joined in the band and said sexual orientation is protected. So there's some conflict there. Interestingly enough, the president fired a couple of the EEOC commissioners and appointed a woman who was already a commissioner, but had some very different views about how to interpret Title VII. She's a very interesting follow on Twitter. I won't call it the other thing. On Twitter or LinkedIn, she has some very strong positions. And one of the things that she immediately came out and said following this executive order is that we will double down on protecting women's rights against all kinds of activity. And I was like, wait, well, I thought we were already doing that. But when I read further, it was more about this, that, it is two categories. We're sticking with it. When people put their pronouns in their emails, we don't care about that. We do not acknowledge that. And so the federal funds cannot be used to support any kind of gender ideology. And again, the key issue was really that privacy in the intimate spaces. And again, even for the sports fans out there, where this has popped up. It'll be interesting to see how it manifests on the athletic fields and in the swimming pools about, who can compete as a woman and who can compete as a male. I think if it's anything connected to the federal government, you're going to see a lot of controversy about that. Folks who are transgender are likely going to have to fall out of those competitions if there's any kind of, particularly I would say at the collegiate level, where schools take federal funding, you will see manifestations that way. And so it is, again, that sex is binary, and the federal government, you have to go through and scrub and make sure that your practices align to that. Next slide, please. Next slide. I think we might have a duplicate. Okay, so I will kick it over to Joyce.
Actually, before we get Joyce,
Yep.
before we get here, and I'm throwing this out there, this is unrehearsed. What should an employer do regarding the bathroom situation? They have a transgender employee or employees, and as I understand it, within the Fourth Circuit at least, I think it's a 2019 decision, in which a student who's transgender sued to be able to use, it may have been the male only restroom. Factually, the Fourth Circuit held, I think this is the Grimm case, held that it was discriminatory for the school system to not permit the transgender student to use, in this case, I think the male specific restroom. And they appealed to the Supreme Court, and the Supreme Court declined to hear the case. So, like Bostock that Aisha mentioned, we have in this geographical area, I think, at this point, controlling precedent under federal law, dealing with that scenario that's very practical for employers. It's like, what do we do? And so I want to raise that and get your, if you all have any thoughts on that, and what should an employer do? And from the plaintiff's employee standpoint, Joyce, if you had a client in that scenario, maybe what would be your perspective on that for the client?
Sure. So Bostock is a very important decision. It's recent. It's 2022, and it is good law. It ruled that transgender employees have protection from discrimination. That's the law. I would continue to follow it, not just federally, but of course, you've got the local county and state laws that mandate these things as well. So, in figuring out what to do about bathrooms, you mentioned the Fourth Circuit law. That's absolutely right. The existing law in Maryland is that transgender employees are entitled to reasonable accommodations regarding restroom access, including gender-neutral facilities. That's still the law. The employers are required to use pronouns that align with an employee's gender identity. There should still be health coverage for transition-related health care. There's a right to transition at work when you study all the case law. There's a right to dress according to gender identity, a right to your privacy concerning your transgender status and medical information. You have a right to fully updated employee records. That one's going to be tough for all of us. A right for insurance records and cards to reflect this. Keep in mind, while Bostock interpreted Title VII to include transgender protections, Maryland expressly includes it in their statute. Employers may not discriminate on the basis of an individual's gender identity and expression. Virginia Human Rights Act protects employees based on sexual orientation, gender identity. District of Columbia, same thing, sexual orientation, gender identity expression, all expressly prohibited. And DC's goes even further and expressly prohibits employers from preventing employees from using gender-specific facilities, echoing what the Fourth Circuit said. So be aware that as you act to try to come into compliance with federal policy, these transgender employees have rights still under federal law and express rights under state law. And so you're going to have to tread very, very carefully there.
From the employer's perspective, from a very practical standpoint, to the extent that your organization can do this, just have a bathroom. If you go to restaurants, particularly on the West Coast, but even here, you just have a restroom, and it's not designated anybody's gender, and it just is, it's occupied or it isn't. So that's one way. If you could even have restrooms that are just neutral, that everyone can use, that's, I think, I don't know, maybe Joyce will have a different perspective, but I think that that's one way that you can just deal with the practicality of it all. And actually, it probably will free the bathrooms up more evenly, that people have access if they're not designated one gender or another. But that would be one practical thing I would look at in terms of the feasibility of your organization, if you were to just not designate any kind of gender, but just make it a restroom. That may be helpful.
Aisha and or Joyce, it might be a tougher scenario. Maybe larger employer has a fitness center on site. They have locker room, changing rooms. Thoughts on that?
I mean, that's a tough one. Again, there's certain places, in the restaurant. I was at Under Armour for 7 years and had beautiful facilities. And there are doors that are closed and places like, if people, they're always the people who are very confident in their bodies and they walk throughout the locker room, and there are the people who need a little bit more private space. So I think making sure that there's some of that private space available may be something you have to look at. But again, working with your facilities folks to see what is feasible, to give folks who may not be comfortable in either event a place to go. I don't know about the wisdom of like putting up a sign being like, hey, the transgender person's in here right now. Like, I don't think the wisdom of that. So we just would have to huddle up and figure out the best way to do it.
Aisha, I'm curious. I listened to your advice on how to handle, bathrooms. Does and not to throw a really hard question at you, but does your advice differ if the bathroom is multiple stalls and not an individual stall, right? Very easy to say that individual stall bathroom with a locked door, anyone can use it, one person at a time. What's your advice on employers whose physical and structural facilities are a multiple stall bathroom?
I think that is a tougher question. Just spitballing, I would still designate it as an all-use restroom, and maybe I would prop the door open like at all times, because I think, part of listen, so I have kids. When my boys were little, I would be nervous about sending them into a restroom where there were other grown adults. And so I don't want to minimize the fears that some people may have about going into a restroom. But if you go in and there's someone, like, they're not in the stall with you. So if you're aware that other people of different genders and identities may be in that stall, it's keep that door open. Make sure everyone is aware that it's open to all. Since we keep talking about things being open to everyone, it's open to everyone, and just use the restroom. I don't have a perfect solution, but that's what I would advise my clients who have the multiple stalls.
And this is kind of a very general question, but looking at the top, the executive orders and the topics we've been discussing so far, maybe a dated phrase, but sort of the idea of reverse discrimination. The pendulum here is swinging back in a different direction very dramatically. And do you think there may now be even more claims filed on behalf of employees? Let's say a Caucasian employee at a company and finds out, hey, they've got the DEI director, they have this DEI program, and it probably would need to be more specific than that to actually state a viable claim of like discrimination. But do you think that pendulum in that direction may swing back here? And it certainly seems like, if so, there would be, a friendly view of that from the enforcement level, for example, from the EEOC as a general matter.
Yeah, I will tell you, my firm is already receiving calls from people. Hey, 20 years ago, I should have gotten a position and they gave it to a woman, and I'm sure it's affirmative action. We're getting calls like that we didn't used to get. But I will say, in some ways, you shouldn't see a change, right? Certainly, I've always viewed Title VII as race blind, gender blind, right? And in fact, one of my jury verdicts in the last year was for a white male firefighter. Male is a gender, white is a race. And we have always taken those cases. And in fact, Ruth Bader Ginsburg was famous for saying she loved to take the reverse discrimination cases and establish law with them. So many of us have not hesitated to take good reverse discrimination cases, but I think you might see more people coming forward with them, thinking about them, and calling to try to find people like me to bring them forward.
So I'm a New Yorker by birth and upbringing. So I'm going to just say something, and I don't want to offend people. I'm offended that if a woman or a person of color occupies a position, people automatically tag it as a DEI hire and someone who is not qualified to do that job. So I am already seeing the reverse discrimination claims, but I wouldn't say to that person, show your work. What is it about you that makes you eminently more qualified than the person who is occupying that chair and doing that work? To me, it's borderline offensive, this term that gets thrown around about DEI hire, because it starts from the place that the person was never qualified. And any employment attorney worth their salt will guide their clients to saying, you always anchor to the qualifications. You're always anchoring to the qualifications. The fact that someone may be a woman, and I always say women because women have benefited, and white women have benefited more statistically from affirmative action programs than people of color. But it bugs me when people jump to those assumptions. Like, you see me and you go, oh, she's not qualified. I'm like, I've been a vice president at a global company. Like, that wasn't an accident. So show your work when you get those complaints. As an employer, I would still say, we have to recognize that the statutes were put in place because there were people who were historically disadvantaged. And so how were you disadvantaged in the hiring process? Did you get an opportunity to apply? Did you get an opportunity to interview? Did you have all the skills? Maybe you stunk in the interview. I don't know. But show your work. I used to always say to my GC at Under Armour, like, John, we may settle, but we're going to make them work. We're going to make them work for it. Like, as an employer, you just can't, again, within your own risk tolerance, you can't just automatically shrink because someone makes a claim. So anyway, that's my spiel on that.
Very good. Joyce, take it away.
Sure. This is something that's non-competes have been in the news for the last year. So I know everyone's been hearing about it, talking about it. And this is about the Federal Trade Commission's ban on non-competes. What are non-competes? Those are the things that say an employee can't go to a competitor within a certain geographic distance for a certain time period and compete in a similar in a similar role or duty as they did at the previous employer. So this does not touch non-solicitations, right? You can't solicit my employees, you can't solicit my clients, not touched by any of this with the FTC ban. It's not even a year old and has had a tortured history. The FTC came in and they banned most of the non-compete agreements back in April with an effective date in September. It created a lot of havoc. And it was very broad. It basically said you're not going to be able to enforce your non-competes. It included things like independent contractors, sole proprietors. I mean, a very broad ban, and even had a retroactivity element where it required employers to contact their current employees and say, hey, that thing we made you sign all those years ago, I can't do anything about it, rip it up. About as broad as you get. Next screen. So what is the current status? I remember giving presentations on this headed into it during the comment period, and I predicted. I said there's going to be a lawsuit from the Chamber of Commerce within 24 hours of this actually getting approved. I was right, and it was a very strategic lawsuit. They took it to a specific court in Texas that is very pro-employer, which would then put it on the track to go to the Fifth Circuit. This was a very strategic move by the U.S. Chamber of Commerce to do this. They lined it right up in that Texas court, and they struck it down in 2024, issued an injunction saying you're not allowed to enforce this yet. There are a lot of reasons. I've included some here, but I could probably go through a list of 10 reasons they struck it down. One of the biggest reasons, though, is that the Federal Trade Commission isn't allowed to sort of occupy the antitrust world, right? They're not allowed to deal with competition and unfair competition. That's not within what the FTC does. And so they exceeded their authority. Another reason that this hasn't been upheld is it was found to be arbitrary and capricious because it was so broad. Courts, if you read the opinion, say it lacked a reasonable explanation, maybe not their strongest argument. There's a lot of proof out there that non-competes can restrict an employee's ability to move. It shrinks hiring pools. So they have their reasons for doing it. And I predicted if there was anything that Aisha and I might disagree on today, it's non-competes. But that was another reason. It's just very, very broad, and it's retroactive. So it was struck down by the Fifth Circuit. FTC has appealed. That's where it's at right now. I want to add there was a Florida federal court that held it unenforceable, had a very different analysis. Be aware of that. They kind of disagreed a lot with the Texas court, but at the end said it's not okay, but it was for a single employer. It's not a nationwide ban. That one is at the 11th Circuit as well. Next slide. My predictions. I love to give this and then figure out how closely I came. I frankly think the FTC has an incredibly difficult path in this litigation because there's so many issues flagged for why this violated the law. And I think they need to win on all of them. And so it's going to be an uphill climb for the FTC on these appeals. As far as timeline, I put it in this slide. I checked the timeline of Fifth Circuit notice of appeal. I don't practice in the Fifth Circuit. I do the Fourth Circuit, but I checked the timeline. It's much faster than the Fourth Circuit. It's about 7 to 8 months to decision from the notice of appeal, which means we don't expect decisions on these until the middle of the year. And if you get a circuit split where the Fifth Circuit finds something different than the 11th Circuit, it's going to head up to that U.S. Supreme Court, which means we won't have finality on this topic from a judicial standpoint until 2026 at the earliest. Next slide.
Joyce, one question real quick. So the rule, this was a notice and comment rule, is that right?
It was, yes.
So could the new, newly led FTC under the Trump administration, they can't just yank it. Is that accurate, your understanding? And I'm not an administrative law expert, so I just thought, is this one they could just, if they have a change of view, could they just, withdraw the proposed rule or through executive order? I'm not fully sure the answer myself, but.
Yeah, I think technically, if you drill down into administrative law, because it went through the notice and comment process, it can't just be withdrawn. My prediction is it's going to be abandoned, right? I think that, while they may not do an official withdrawal, or maybe they do and it's illegal, but I think they're just going to abandon it, whether they do it properly under the procedure or not, I think is what's going to happen.
Okay.
I think it's a similar thing. I'm sorry to interrupt. A similar thing just
please.
happened with a lawsuit out of Georgia about transgender insurance rights, where the new administration has actually withdrawn their support. So they were kind of like co-signed to the lawsuit, and they recently just said, nope, never mind. That's what I see happening here with given the current administration, that eventually there's just not going to be steam behind it.
Yep. Yep. I think that's obvious where we're headed with it. And just like, Trump recently appointed Andrew Ferguson as chair of the FTC, and there's also been movement among the commissioners. Andrew Ferguson has been a very vocal opponent to non-competes, so the head of the FTC doesn't believe that they should be banned. There's not going to be any motivation from this administration to pursue this. So, and frankly, I think, what I know of the Fifth Circuit and the 11th Circuit, I think judicially that's probably going to line up as well. And if it goes to the Supreme Court, I would suspect the same thing. So I sort of think the idea of a ban has got a very, very steep hill to climb on both fronts. Next slide. All right, so let's talk about state level bans. One of the things as we talk about the FTC, and their ban, we need to keep looking at local jurisdictions. And, I do a lot of I'm the legislative liaison for the employment section to the Maryland legislature. So I'm always looking at bills and where they're coming from. And there's a trend across the country to narrow what you can do with non-competes, ban certain types of non-competes. I do think you're going to continue to see that trend, as time goes along. So even if the FTC ban is dead in the water, you're going to see local actions that continue to narrow and limit what you can do. Next slide. Let's look at Maryland. Maryland has acted to limit it and ban it for low-wage employees. I have it right here. It's for employees who are less than 150% of the state's minimum wage. As you know, Maryland's minimum wage escalates. Montgomery County has its own minimum wage laws. So this one gives you a benchmark to specifically tie it to figure out if they're a low-wage employee. And it also, this same low-wage employee law that came into effect, it requires employers to notify potential employees they're going to require it, right? So you don't quit your job and then all of a sudden get handed this onerous non-compete and think, I would never have quit my job if I knew I couldn't work in the state of Maryland ever again, except for this employer. So that's one of the laws in Maryland. Maryland very recently expanded some of the restrictions in healthcare. And I will tell you, this is a trend across the nation. People don't want to be restricted in their choice of medical care. And communities don't want to be harmed by these non-competes. And that's an argument that legislatures have been receptive to hear. So in Maryland, for healthcare professionals and this is dealing with licensed healthcare professionals, right? So if you're a receptionist at, a medical practice, this law doesn't apply to you. But it can only be limited to 1 year unless it's a sale of a business. It's prohibited for physician assistants. You can't have a non-compete there. And veterinarians and veterinary techs are included in this law, but no salary cap limits. By salary cap limits, Maryland has had a salary cap of $250,000. So you can only have this law apply and have a non-compete if the employee makes over $250,000 a year. Next slide. Virginia. They've got another one. And again, enforcing these against low-wage employees, a popular trend across the nation. And frankly, it was hard to do even before these laws came into effect. You had to prove that these employees, had something and there was a legitimate interest on the business side to protect that employee from using your trade secrets or your client lists or the secret sauce that they got at your company. And a lot of these low-wage employees don't have that kind of information. And really the idea of non-competes is governed a lot by confidential information, right? The person who might be like a janitor isn't going to know the trade secrets, the client lists. So it's always been very hard to enforce a non-compete against some of these types of employees even before this legislation. But in Virginia, the Virginia one boggles my mind a little bit. Again, as an employer who also represents employees, they have a moving target, which is crazy to me. And I put it in here, and I want to make sure I say it right. A low-wage employee earns average weekly earnings that are less than the state's average weekly wage. Okay, so I didn't know what that was even as I was preparing for this, so I had to go look it up. How many companies say, well, what's the average wage right now? I think that's tough. And I went and looked it up, and it's approximately $73,000 annually. And I was shocked to kind of read that, because if you pull aside a Virginia worker who's making $73,000 annually and say, did you know you're a low-wage worker? I think you'd probably surprise some of them. So this one I find particularly interesting with a moving target. It's targeted at low-wage employees, but when you look at where that falls and figure out that moving target, at least for the year of 2024, it was $73,000. So this one is one that I think you need to exercise care in how you're approaching it, because there's just a lot of things you need to know. Next slide. DC also, and again, no moving target, nice and easy. 150,000 per year. They don't call that a low-wage worker. They just say, here's the cap, right? So DC has a pretty broad ban already. And they have one again on medical specialists. And again, if you earn 250,000 or more per year, you can be subject to the 2-year non-compete only if you earn more than that. So there is some room there. But again, one of the most restricted jurisdictions in the Mid-Atlantic area. Next slide. So, federal versus state. I just want to emphasize that non-competes have always traditionally been viewed as a state issue. When we get employment contracts and it says this should be interpreted by Connecticut law or Chicago law or California law, state law in California entirely bans non-competes. It has always been governed by state law. I think state law is where you need to have your eyes in what your company is doing, and that's where it's going to remain, is my prediction. Next slide. So I think we're wrapping up. I do want to give Aisha a chance to talk on non-competes. I know she has strong opinions on them.
We're probably not that far off. I think, fundamentally, most states will say they have to be reasonable with respect to geography and duration. You don't want your admin making a couple of bucks be subject to a national non-compete, right? It doesn't make sense. Fundamentally, most states say most human beings should have a right to earn a living. And so internally, take a look at how can I used to always just say, does this person have the headlights into your organization? Like, in other words, how far down do they have visibility into your strategic plans, your know-how, your et cetera, within the next 6 to 12 months? Can they do damage to you if they took that and replicated it somewhere else or shared it with your competitors? Just be thoughtful, because the courts are going to make sure that you're administering it in a thoughtful way, but also in an even-handed way. So you can't have favorites. You can't say, for people within a same job class, I'm going to enforce it for this person, but I'm not going to enforce it against that person, because they'll just knock the whole thing out. So just, be thoughtful. I actually have no qualms about, if there's a low wage earners. I don't like doing math. I always say I went into the law because they said there'd be no math. So much like Virginia, Oregon has a statute like that, where you have to do calculations to determine how to figure out if the person can be subject to a non-compete. So there's just some logic here. Like, what does the person know about my business? Think about it in terms of your different job classifications. And the higher up in the organization, the better you have an argument for something that's national or international. If it's the CEO, conceivably they could hurt you across the country. If it's your admin, you want to ban them from being able to work everywhere. You want to be more sensitive to the geography.
Except on the admin position, right? that in that scenario, the person may actually have access to confidential information, including about customers, depending on the business. So maybe that's a scenario where a strong confidentiality agreement, a strong non-solicitation of clients, customers agreement could be in play, but not necessarily the non-compete clause.
Absolutely. And we always remind folks that the confidentiality survives the employment. So the things that you're looking for comfort, you can still get, and you can also give them reminders as they go out the door about their obligation to keep your trade secrets, your other information confidential.
Very good. I think we're at the end of our comments. Any questions on anything discussed at this point? If you could put it in the chat, or you can just raise your hand on the Zoom and we'll let you speak, or you can.
John, Brad had a question earlier on. If it will be merit-based, how did some of the cabinet members get nominated and confirmed? If it was a blind resume, a number of them don't meet minimum qualifications. Seems like a double standard.
I'll let Aisha chime in, except weigh in. My thought is, at that level, the president can pick whoever he wants if he thinks he or she can get them through the Senate, right? The confirmation process. So maybe it's more the rules apply to thee, but not to me in that type of scenario. Aisha, what do you think?
You have to have the advice and consent of the Senate. Conceivably, they're going through a process where their qualifications are being evaluated. Can you see my tongue in my cheek? So I think your comment in the chat was laced with sarcasm, Brad. I would be more inclined to agree with what you've said in there.
And then we have a question, considering the LBJ-EO was related to gender and race, what is the status of affirmative action requirements regarding veterans and the disabled?
I would say that those are still in place. What entity remains, there's some talk that some of the duties and responsibilities of the OFCCP will be subsumed into the larger Department of Labor. And so we still have to see how that shakes out.
Yeah.
I agree.
And Margie, could you put up the conclusion slide? Just unless there are other questions, I think we are at the end. And I just want, if we can
quick,
go ahead.
Shameless plug. You may be able to see my QR code there, that I have a free guide for employers to check out, just a checklist to watch out for you as you navigate your business. Would be happy to share that.
Very good. Thank you. So Joyce, Aisha, thank you so much. And that last slide, it's been up for a while. I did list the email addresses for Aisha and Joyce and my own. I think, what are the takeaways? Change is here, change is coming, more change, not less, of significance. Please stay attuned. And frankly, if you run into, as you're evaluating these issues and options, get legal help if you need it. And I can't thank Aisha and Joyce enough. I think their comments have been extremely helpful and informative. And Margie, thank you in the chamber for hosting.
Thank you very much, John. Thank you for everyone attending.
Thank you, John, for putting this together and all the work you put into it. Thank you.
All
So
right.
much. Really appreciate it.
Thank you, John.
Okay.
Can I ask one last question?